Lawyers about health and safety at work. Is it safe to go back? What happens if you refuse? We're already getting all sorts of questions, and we have an expert for you all program. Howard Levitt's back with us, an employment lawyer who's going to answer all of your matters. And there he is at home in Toronto. Nice to see you again, Mr. Levitt. Thanks for coming back as our expert today.
Well, thank you for having me.
I have a little bit of reading for you because the first batch of questions are all sort of variations on a theme, but they're slightly interesting. Well, no, they're more than slightly interesting. The slight variations are interesting, but they all lead to the same place. So, Rika, working at a warehouse where there are up to 500 people on a single shift of 10.5 hours, wondering about, is it safe to go to work? Steve, working in a factory, 3 feet away from each other, so a meter away. I don't understand why we're still working. Can we be forced to work? Alan, a construction manager with anywhere from 40 to 60 workers on his site. No choice to interact with them, and he's worried about bringing COVID home to his wife. What are my options? And Erica, in a hair salon with an owner eager to reopen. What rights do employees have in regard to our health when we return to work? So those are 4 different slightly variation scenarios, but it gets to the same question of, if an employee considers the situation unsafe, too risky, can an employee refuse to work? What are his or her options?
Well, first of all, it's not up to the employee to decide, because some people, led by the government to some extent, are saying it's unsafe to even leave my house. It's unsafe to go to grocery shopping. It's unsafe to do anything other than stay home. So that's not the test. The test is it objectively unsafe? And if it is, they don't have to work. Now, how do you test that? In every province, it's the same. If you think it's unsafe, you tell your employer, you discuss it with your employer. If you can't come to a solution, if the employer isn't prepared to create an environment that you think is safe, you call in a Ministry of Labor health and safety inspector. Either the employee or the employer can do it. The employee does not have to work until the inspectors come in. And when the inspector comes, they say one of 3 things. One, it's just unsafe. People are working too close together. You don't have to work. Period. They'll probably shut it down. Secondly, it's entirely safe. Go to work. And what most often happens is the third choice. It isn't safe right now. You're right. But employer, you have to make the following modifications. Ensure people's stations are at least 6 feet apart and wear personal protective equipment in these particular jobs. Whatever the case is, they are experts in what is safe in this environment right now. They make that determination, they make that ruling. At that point, if the employee refuses to come to work, they could be fired for cause and will lose their CERB benefits, they'll lose their EI, and will lose their job. But if they say it's unsafe, of course, no one should be working.
That is absolutely crystal clear information and so important, and answers these very questions. Does it matter, I wonder, whether it's a unionized or non-unionized workplace?
Not in the slightest, except the unions have pretty good access to health and safety inspectors, and they're the ones calling them in to some extent these days.
So, but the obligations are the same. So go to your boss,
Identical.
have that discussion, and then it could go up from there.
Yes. Now, if you're unionized, you might want to have your discussion with the union, who will have your discussion with your boss or with the company. But otherwise, it's exactly the same and the very same test.
Okay. So then most of the questions that we're getting so far, Mr. Levitt, I'll just let you know, are from the employee perspective. So I want to make it clear from the other side of things right now, from the employer. Again, given that health and safety legislation, what are our employers' obligations right now as they think about inviting their workers back to the office, to the workplace? What are the obligations and considerations for an employer right now?
Well, let me give you the number 1 consideration. You don't want to get sued and bankrupted. And if the reality is, if you don't maintain a safe workplace, if you're careless, if you're sloppy, if you don't do all the things I'm about to suggest, and employees come in and they get sick from COVID because other employees with COVID come into the workplace, you can get sued potentially for people's death or serious illness. And whatever else you want to think about a particular employer, no one wants that. And no one wants that. So what employers have to do is make sure they have a safe workplace. First of all, require social distancing. Secondly, have sanitation stations, lots of cleanliness, making sure it's regularly cleaned. Make sure there's facilities nearby to wash your hands as frequently as possible in addition to sanitation stations. Make sure that anyone with COVID symptoms or flu symptoms or sickness is not permitted into the workplace, and that's widely announced, whether it's members of the public or employees or anyone at all. Then discipline people who break any of those rules, who refuse to socially distance, for example. And if you do all of those things, you have a safe workplace. And then you can invite your employees to return to work. Now, many employees don't want to return to work right now. They're saying, gee, I'm getting $2,000 a month on the CERB. You're paying me a little more than that. Why should I come back to work? Well, the answer is we've got to get the economy moving again. We've got to get businesses started again. And if employees refuse safe work, and ultimately a health and safety inspector can verify it's safe, they lose their jobs, and they lose their CERB, and they lose their EI.
Okay, so if everything is safe and the employees still refuse to return to work because, as you said, it's maybe not completely solved, this COVID situation, and they're on CERB and they're getting money, but if they refuse to come back to a safe, designated safe workplace, what happens to them? What can the employer do? Dismiss that employee.
The employer should say, you have to come back to work, and if you don't, I'm going to be terminating you for work abandonment. I'm going to be issuing a new record of employment, and that will cut you off not only your job here, but perhaps more significantly for the employee at the moment, it will cut you off CERB, it will cut you off EI. The employee will have no income. So that generally is a powerful persuader to get people back to work. And it's tough right now for employers to get, especially lower wage employees, coming back to work.
Employers need to know a lot of considerations, a lot of information for employers and for employees. I think this is going to be a very, very insightful conversation this morning that we're going to carry on over the next 3.5 hours, Mr. Levitt. So I'll speak to you in the next hour. Thank you for this first conversation.
I look forward to that.
And thank you for the questions so far. Many more to come for employment lawyer Howard Levitt. If you want to make sure that your question is asked today, here's how you reach us: morning live at cbc.ca and at CBC Morning Live. As Canada's economy begins to open up, we have questions coming in about the return to work, and answering them for you this morning is Howard Levitt, who's an employment lawyer, who's with us all morning from Toronto. And nice to see you again this hour. Listen, the questions are rolling in. We're really on a really interesting touch point, I think, for Canadians right now. A lot of questions about rights and obligations with this return to the workforce, Mr. Levitt. So let me ask you, number one, a question from a bus driver who would like to remain anonymous, but you could think that this perhaps isn't just limited to people in the transit sector, but are workers allowed to wear a mask when an employer has deemed it not part of the uniform?
Absolutely. No employer has a right to prohibit an employee's ability to feel safe, both physically and even if it's psychological. If you want to wear a mask in your workplace, wear a mask in your workplace, and no employer can say no.
Even if you're in the restaurant sector, for example, dealing with customers that may be off-putting anywhere?
There's always exceptions, Heather. You're right. I should not have been so unequivocal. But in jobs like bus drivers, there's no issue at all. Certainly, if you're a customer-facing public service type of job, for example, you work at agency, seeing a client, they might not want you wearing a mask.
Right.
But for 99% of Canadian workers, fair go. And even in a restaurant, I think an employer would have a hard time these days saying we don't want you wearing a mask. Certainly if you're dropping off food or if you're dropping off food at doors. Servers, 50-50, depending on the circumstance, but I think there'd be a strong argument either way.
Okay. Excellent question. Thank you from that driver. Another anonymous question: are employers being made to hire staff back, workers whom they previously laid off, especially if they have adequate funds to do so?
If you don't hire them back when you're able to, it becomes a wrongful dismissal. I mean, the reality is that outside of Alberta, any layoff is a wrongful dismissal. Most employees are saying, we don't want to take the chance of never having a job again. So we're accepting this layoff, but on the basis we get called back. If they don't call back, then they have a second chance to sue for wrongful dismissal, both when they originally laid off and when they're not called back.
Excellent question. Peter has a next one, Mr. Levitt. He's a student, and this is a really interesting nuance here. If a student had a standing offer for summer employment before the pandemic, but the shutdown led existing employees to be moved into the student positions, what rights do the students have?
They can sue for wrongful dismissal, actually. If you have a job and the employer changes it, rescinds the job offer, that's a wrongful dismissal case. The other thing is, in those circumstances, the government is providing benefits to student employees. Not as high as the benefit, not as high as the CERB. I think it's $1,250 a month, not $2,000 a month, but those benefits are being given to students. But in any event, you can sue for wrongful dismissal even before your first day of work if a job is yanked from you before you get to start.
We were talking last hour at length about an employee's right to refuse work if he or she decides it's unsafe, and then the processes that would determine if, in fact, the workplace is too risky and is unsafe. An anonymous question, this is a variation on that. What's your opinion, Mr. Levitt, on the right to refuse work on the grounds that the public transit system is unsafe to use and you have no other means of getting to your place of work?
That's a very common question right now and a very common concern. My view is that how you get to work is essentially your responsibility, and you can't use that as an excuse not to attend work. The question is the workplace safe? And if the workplace is safe, meaning social distancing is required, sanitation systems are set up, PPEs or personal protective equipment is provided as necessary, no one with symptoms is allowed in, and people are disciplined for breaching social distancing or coming to work sick, then the employer has the right to require employees to attend, and how they get there is not the employer's legal concern. Now, nor is not being able to get there other than by public transit a legal excuse for the employee not to attend.
Would it be a similar thinking for someone who has a partner or spouse, or I would think maybe even a child in the family who may be immunocompromised, and by reporting to work, the person runs the risk of infecting family members at home?
If you can get a medical certificate saying that your partner is immunocompromised and there's that type of danger from even leaving your house, the courts, I believe, at the end of the day, will make an exception. I think the inspectors, the health and safety inspectors who are adjudicating on these issues of what's safe and what isn't safe, in my view, and of course, these haven't been tested yet, but in my view, they will make an exception. That will allow the employee to stay home and to collect CERB. But it had better be a legitimate case, obviously.
I have to let you go this time, but you just said an interesting thing. They haven't been tested yet. Do you foresee, once things are back to normal and situations arrive in workplaces, are these going to be the kinds of cases and issues, grievances that are brought forward? Do you anticipate, Mr. Levitt?
Well, I think they're being brought forward right now, because right now inspectors are making these decisions. The problem is you might get one inspector in one town making one decision, and another inspector, maybe even in the same town, making a different decision, because these are all new issues arising for the first time in our history, and for the first time that these inspectors are dealing with. They have to ask themselves, is this particular situation safe for this worker and safe for their family?
These are such interesting questions and answers, and so timely. So I'm looking forward to the next installment, next hour. I'll look forward to rejoining this conversation then. Howard Levitt, an employment lawyer who's in Toronto for you. And again, we're having some wonderful questions. Already have many for next hour, but there's still time for you to submit yours. And again, here's how: morning live at cbc.ca and on Twitter at CBC Morning Live. So the issues that Carolyn raises in her report and that come from the Cargill situation really tie into our expert for you this morning as we talk about questions about returning to work, both from the employee and the employer perspective. Howard Levitt is with us today, an employment lawyer in Toronto, getting some excellent questions from you and providing some fantastic expertise. Good to see you again this hour, Mr. Levitt.
Thanks for having me again.
We have very astute viewers, I will say, and I want to clarify something, because we were talking last hour about if the workplace isn't safe and the opportunity to sue one's employer. And then we heard someone wanting clarification. Can you sue if your workplace is covered under a provincial compensation board? Maybe there's a nuance there we should make, Mr. Levitt.
Well, if those are covered by workers' compensation, then of course your application would be to the WSIAT or the WCB in your respective province if it's caused at work. But if it's not, and not all employees, not all companies are covered by workers' compensation, then you have a right to sue your employer directly. And of course, the amounts you would recover are dramatically greater in a lawsuit than under WSIB.
All right. Important clarification. Thank you, Bill, for writing, and thank you, Mr. Levitt, for clarifying. Andy has a question about potential legal action, wondering if there's any possibility for lawsuits if an employee falls ill from COVID-19 after being exposed at work.
The question is this: if the employer was negligent, if it didn't require sufficient safety precautions, if it let people into the plant without checking to see if they might have COVID symptoms or not, in other words, if it was reckless, then they could sue for negligence and recover. There have been cases in the US so far, but there have not yet been cases in Canada. But there will be yet. I'm confident of that.
Rick is wondering, he was told because of the pandemic he may not be called back to work through until September. Does the company Rick works for, Mr. Levitt, have to continue his benefits?
There's no right to lay people off at all if you're not in a union or if that's not part of your contract of employment. Under the Employment Standards Act, you're allowed to keep people on layoffs for a longer period of time to keep benefits. But the reality is, what people don't understand, because everybody's being laid off across the country right now in such massive quantities, that an employer does not have the right to lay you off at all, with benefits or without benefits, and a layoff is a constructive dismissal, allowing you to sue as if you've been fired. Now, if you're laid off and you accept it, then under the Employment Standards Act in every province, there's a different period of time before it becomes deemed termination again. And it's a longer period of time. If you have benefits, it's 35 weeks in Ontario with benefits and 13 weeks without benefits, at which point it becomes deemed termination again, giving you a second chance to sue your employer. You also can sue your employer if they don't recall you when they recall other people, even before the 13 or 35 weeks expire. It's a bit complicated, Heather, but those are the rules. It is a little bit.
It makes me think, though, that you're saying that essentially he should still be covered. And if he's not being covered, what recourse does somebody like that have?
Well, he may not be covered. Some employers are laying people off with no benefits at all. It just means their termination is going to be triggered at a sooner period of time. And no, there's no recourse except the recourse of claiming I'm not accepting this layoff at all, with or without benefits, and I'm suing my employer as if I'd been fired, because the basic employment bargain is that an employer provides work, you provide your work, the employer provides pay in return for your work. When the employer stops paying you by calling you furloughed or laid off, that's a breach of the employment agreement, allowing one to sue if you want to. Now, you may say, it's not worth it for me to do that. I'll ruin my relationship with my employer. I'll never be recalled. I only think this will be a month or two, so I'll hold off and take those 2 months without income. But some employees will say, I'm not very happy with this employer anyway, I'll sue right now. That's a decision every employee in Canada has to make.
Actually, a couple of questions about working from home. Both sides of the work from home issue. Don is writing, and I'm going to read this because there's some interesting nuance to Don's question, but I don't like working at home, says Don, and I feel I would be more effective at the office, but my supervisor insists I work from home. Some of my workmates are allowed to keep going to the office. Does my employer have the right to make me work from home when others do not have to? And should working from the office be a workplace accommodation?
Well, it depends. Right now, because of social distancing, you can't fill your office with people. That's just, unfortunately, a health and safety reality. So the employer has the right to say, we need some of you working from home, and to designate who they're going to have work from home. In a normal environment, your work is at the office, and they can't make you work from home. They have to let you work at the office, unless, of course, your particular agreement is you do work from home. But for most employees, they can't suddenly be told, they can't be banished from the office and told they have to work at home. But right now, because of social distancing requirements, it's acceptable for the employer to say that.
On the other side, though, people who have been told to work from home and are finding that they can do their jobs from home, if the employer calls them back to the office, do they have the right to say, I can do it from home and I prefer to stay at home?
Well, Heather, I'm on the employer's side on that one again. Unhappily or happily, depending on which side you're on, the employer decides where the work is to be conducted. An employee has no right to work from home, even if they could objectively prove that the work is more effectively accomplished from their home and they get more hours a day because they're not commuting. The employer can say, I don't care. We want you here in the office. We want you working with other people. We want you in a position where you can be supervised. We want teamwork. We want esprit de corps. We want work done in the office. That's the employer's right.
Howard Levitt, Let's talk again next hour. I have more questions for you. They are excellent ones this morning, and I really appreciate your guidance on all of them. Speak to you soon.
Thanks so much.
All right. Thank you very much. Howard Levitt, an employment lawyer in Toronto. Now, we want to take a quick live look at auto.